All rise. We will lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. We will s'asseoir.
Thank you very much. Court officer, the case, please.
Thank you, Mr. President. The situation in the Republic of Kenya in the case of the prosecutor against William Samuel Ruto and Joshua Arap Sang. ICC 0109-0111. We are in open session.
Thank you very much. Appearances?
Morning, Your Honours. For the prosecution, appearances remain the same.
Good morning, Your Honours. The same. Thank you. Good morning, Your Honours. Mr. Sang's team remains the same.
Mr. President, Your Honours, good morning. The defence team of Mr. Ruto remains the same.
Thank you very much. Mr. Keegan-Katwa, you requested additional time.
Mr. President, I had very kindly requested for an additional 15 minutes. There are two areas which I very much thought I needed to cover, and I have every expectation to be able to cover them within 15 minutes. I now have given an indication of a much shorter time. I unfortunately underestimated how much time I needed. I very kindly request for your accommodation.
Right, try and do it in 10 minutes. Mr. Mutai, I note your presence as well. I had forgotten to recognize you during the appearances, but I note you are present in Nairobi with us, with a witness.
Thank you, Mr. President.
Witness, welcome back. Mr. Keegan-Katwa will finish up his cross-examination of you.
Thank you, Mr. President.
Good morning, Mr. Witness.
Good morning, Mr. Keegan.
The first thing I want to do is to go back to the audio that we played yesterday of the 25th December 2007, which is at tab 12. And I would like to play timestamp 21.32 to 22, just so that we confirm who read the number plates of the motor vehicle. The ERN number is Ken-D11-0013-0028. Mr. President and Your Honours, my interest, Your Honours will see at page 579 that Mr. Sang said something, then Mr. Taru said something and read a few vehicles which we did yesterday. Then subsequently Mr. Sang interjects, and the impression that transcript creates is that Mr. Sang read the rest of the number plates. I just want to go on record that in fact it was not Sang who read the other 20 number plates. I will play the audio.
KZ 178R nebo KBS number go 812 Nissan Diesel, KBA 034N nebo City Hopper, number of City Hopper ko 485.
Koro kari chikap City Hopper ko ba Nairobi town jege. Kunguta ka oro Eldoret, ka oger ngap Sabit, ka oro Kabarnet, ka oger ji Mombasa, ka oger ji Kisumu, akano.
Number etage ko KAZ 027F nebo City Hopper, KAW 022W.
Mr. Witness, in the yesterday's questioning, you confirmed that you can hear Mr. Sang's voice, but could you confirm if it is Mr. Sang who is reading those number plates?
It is not Mr. Sang.
Now, I would like to move on to a different issue.
Mr. Keegan-Katwa, your point being that the transcript is not as accurate as it should be.
That's exactly the point, Mr. President. Now, Mr. Witness, I want to take you to tab 36 of Ruto's bundle of documents, and this is a document that was also in the bundle belonging to the prosecution, and it is Ken-OTP-0117-1059. Mr. President, for purposes of these questions, I would request that we go to closed session briefly.
Closed session? A private session, rather, sorry.
I apologize, it's private session.
That's all right. Did you say tab what?
Tab 36 of Ruto's bundle, Mr. President.
Mr. Keegan, could you please repeat?
We are in open session, Mr. President.
Now, Mr. Witness, you were taken in the course of cross-examination by the prosecution through various conversations that you had with a lady to whom you have made reference and identified in private session. Do you recall that line of cross-examination?
Yes.
Now, from the statement that was availed to the defense, I noticed that in all instances, she is the one who called you as opposed to you calling her. Could you confirm if my understanding from the statement is correct?
You are correct.
Do you know why she initiated all these calls?
No.
Now, you said at a certain point, or more specifically in an affidavit, that she is the one who recruited you. You went on to tell us that she is the one who explained to you the substance of what you are supposed to capture in your statement if you are to qualify as a witness. You recall that?
Yes.
Did you have the impression that, in fact, the prosecution trusted her?
Yes.
Did she seem to be aware of what other witnesses had said?
Yes.
Witness, what gave you the impression that the prosecution trusted her? Can we go into private session for that question to be answered? Don't answer it yet. We'll go into private session.
We are in open session, Mr. President.
Thank you. Mr. Keegan.
Now, could you confirm whether you had the impression, okay, let me ask you first of all, did you know whether this lady, whom you've been referring to, was coordinating and networking the witnesses for the prosecution?
Yes.
Now, you told us that she advised you on a number of things that you needed to notify the prosecution. May I ask you, is there anything that she requested you to do in your relationship with the prosecution that you expressly refused that you would not do?
Sorry?
You've told us that at various points she would intervene either to tell you what to say or how to conduct yourself, including initiating the call that we went through a moment ago. And my question is, are there instances when you declined either what she advised you to say or declined what she advised you to do?
Yes.
Could you give the court an illustration of one instance? And probably before you answer the question, we could go to a private session.
We will go to private session, and you've been at it for 20 minutes.
We're in open session, Mr. President.
Thank you very much.
Good morning, Mr. Witness.
Good morning.
I'd just like to follow up very quickly on one issue that my learned friend for Mr. Sang raised this morning regarding a CAS FM broadcast that was played to you yesterday. Your Honours, I'm referring to the transcript at tab 12. Do you recall...
Who's tab 12?
I beg your pardon, the Sang Defence tab 12. The ERN is Ken D11 0014 0568, and for the time being I'm interested in page 0579. Do you recall, Mr. Witness, that you were asked to confirm that Mr. Sang only read out one registration number and that the rest were read out by his caller? Is that right?
Yes.
Did you also hear...
Mr. President, I object to that. Probably my learned colleague would take us to the transcript where Mr. Sang read even a single number plate. My position is that he didn't read any whatsoever.
My learned friend is correct. I withdraw that. In fact, Mr. Terrace read the number plate. There was an intervention from Mr. Sang, and then Mr. Terrace continued to read the rest of the number plates. Is that correct?
Thank you very much. Yes.
Yes. Did you hear Mr. Sang say, just prior to that, and I'll read out the English transcript from the third paragraph of tab of ERN 0579, the English translation is given as follows. Nonetheless, since he has issued a signed press statement and spoken in his own words, read to us the vehicle's registration, just in case people have seen them, whether they are really there or not. Did you hear Mr. Sang say that?
Yes.
So would it be correct to say that Mr. Terrace read out these various registration numbers in response to a request to do so by Mr. Sang?
Yes.
Your Honours, I refer to page 0577 of the same bundle, where in the last paragraph there is similar statements made by Mr. Sang that Mr. Terrace would come and read out the numbers, but I don't think we need to traverse it with the witness. Thank you, Mr. Witness. I'd like to move on to another subject. Perhaps we can call up again the investigator's note that my learned friend for Mr. Sang put to you. The ERN is Ken OTP 0117 1059. It's RO2, the lesser redacted version. Your Honours, it's at tab 36 of the prosecution bundle. I mistakenly said it was at tab 21 earlier. I apologize for that.
Mr. Steinberg, the document is before the witness.
Thank you, Madam Court Officer.
Mr. Steinberg, hold your question. Just a little matter of, to make life easier for everyone, to all parties. When you compare bundles, please place cover pages on each front. The first, basically cover page on each bundle. Either run into series, so you can say prosecution bundle volume 1, volume 2, so that we're now looking at bundle here. We have to figure out who it is that did this, and then, it was the Ruto defense. We should be having cover page saying Ruto defense bundle volume whatever. Thank you.
Thank you, Your Honours. As regards the prosecution bundle, it's in a hard folder. It should appear on the spine of the folder.
In addition to the spine, also do it on the spine if you're using that kind of binder that allows a spine to be had. But it's also on the first cover page inside that needs to be the same.
Noted, Your Honour. Thank you. Mr. Witness, this concerns a report that you provided to a prosecution investigator regarding the incident. Your Honours, I think we dealt with this in private session. Perhaps we can go back into private session.
Private session.
We're in open session, Mr. President.
Thank you.
Madam Court Officer, can you please confirm when we have the floor?
You do have the floor, Mr. Steinberg.
Mr. Steinberg, while the video is being set up, is there a transcript somewhere we should be going to in the meantime?
Your Honours, I imagine there is a transcript in the defence bundle, but I'm not interested in the words, only the pictures.
All
so
right.
we don't need to look at the bundle. I'm afraid we have a technical issue here. The screen has just got a screensaver on it. Perhaps we could get some assistance. While that's being done, Mr. Witness, perhaps I can just ask you, you were played a video of a... let me just pause there for a moment. Your Honour, it does not seem that this is going to be solved in the next couple of minutes. I think I should move on to another point, and maybe we can resolve it in due course.
Would it be easier if the court registry played the video instead of yielding the system to you?
Your Honours, we've tried that.
Right. Okay.
Unfortunately, due to the size of the video, it doesn't play in e-court, certainly not smoothly.
All right.
The defence was kind enough to help us with a copy.
Kenyatta to quit the party, stress.
Kwa sababu tunajua ya kwamba tutafaulu tukiwa pamoja.
Is that what you wanted?
Thank you, Your Honour. We resolved the problem. Can we just go back to timestamp 0043?
Sisi tuko tayari kwenda barabara.
Thank you. Your Honours, can I confirm that you have the image?
Yes, we do.
Mr. Witness, can you see that image?
I have not been shown.
All right, once I can... Yes, you may proceed.
Thank you. Madam Court Officer in Nairobi, can we please give the witness access to this image, which is being broadcast?
Mr. Steinberg, we can see the image.
Thank you. Mr. Witness, you see that now?
Yes.
And can you confirm that this is the same video that was played to you by the defense for Mr. Ruto last week, or earlier this week, I think it was?
Yes, it was last week.
And you were shown a photograph in the defense bundle, and perhaps I can ask that this be called up briefly. It was Ken D09 0038 0072. Can we call that up, please?
Do you remember where it is in the bundle itself?
Yes, Your Honours. It's at tab 7 of the Ruto defense bundle. That's the one in the soft binders.
Mr. Steinberg, the image is being shown to the witness.
Mr. Witness, you can confirm, I believe, that as we can all see, Mr. Ruto in this picture appears to be wearing the same clothing, at least the same jacket, shirt and cap as in the video. Is that right?
Yes.
I'd like you to look behind Mr. Ruto. What is that you see in the background?
I'm seeing people seated.
And above the people that are seated, there's a brown object. Is it not correct that that is a large marquee tent?
Yes.
And take a look at the people as they are seated, a large number of people seated behind Mr. Ruto. You've noted that?
Yes.
Thank you, Madam Court Officer. Can we have the floor again for the video? I'm going to play this video a bit longer, and I'm going to ask you to look whether you can see any such a tent behind Mr. Ruto.
Delegates na wajumbe wataamua ni nani ambaye atabeba bendera ya ODM. Kama maneno ya masikizano hayawezekani, yale ya delegates yakishatokea, watu wasije wakasema tena pengine tungezungumza.
Mr. President, what's happening here is...
Wait, Mr. Fowl, no. Let Mr. Steinberg continue.
Thank you, Mr. President.
What do you see in the background of that picture, Mr. Witness?
I'm seeing plants.
And there are a couple of people just visible on the right-hand side. Is that right?
Yes.
All right. Now, a couple of related questions. Would you agree that the campaigning period prior to the 2007 elections was quite short? It was only a few weeks or a couple of months, if I'm not mistaken. Is that right?
Yes.
And would it be correct then that politicians who are hoping to get elected would have to make the most of the time available to campaign as widely as possible? Correct?
Yes.
And would it be common for politicians who are campaigning to visit more than one event on a day?
Sorry?
Would it be possible, or was it common, to your knowledge, for politicians during that campaign period to attend more than one event on the same day?
Yes.
Can you exclude the fact then that Mr. Ruto, dressed in those clothes, attended more than one event on that day?
It is possible.
Mr. President, may I at this stage raise my objection?
Your Honor, what I want to...
Mr. Fowle, no, you can deal with this in submissions.
All right, thank you, Mr. President. No problem.
Mr. Witness, did you ever see on television or, well, let's stick to television. Did you ever see television or reports of Mr. Ruto arriving at political rallies by helicopter to much fanfare?
I had.
Do you say you had or you heard?
I had.
Okay, so you heard about Mr. Ruto traveling around the country by helicopter to attend rallies. Is that right?
Yes.
And are you aware, Mr. Witness, that when traveling by helicopter, you can travel from Nairobi to Mr. Ruto's house in Sugoi in between 67 and 84 minutes? And, Your Honours, the source for this is KenOTP 00920917 at 0920. Would you dispute that?
I won't.
Right. So you would agree then, Mr. Witness, that the fact that a politician attends a rally at one place on a particular day does not exclude the fact that he might attend another rally at a different place?
Question is overruled. That's argumentative.
Yes.
Witness, when I say question overruled, you don't answer the question.
As the court pleases. I'd like to move on then to, can we call up photograph, also at tab 7, defense photograph. Bear with me. Ken D09 0038 0052.
Tab 7, you say?
Tab 7, Your Honours.
Of the same bundle?
Of the same bundle.
Of photographs?
Correct, Your Honour.
Mr. Steinberg, the photograph is being shown to the witness.
You identified this when asked by when asked by my learned friend for Mr. Ruto whether this was at location D, and you agreed. You recall that?
Yes.
What is it about this photograph that tells you that this is location D?
Private session.
Mr. President, at this stage, perhaps I should make my objection. The witness was showed a series of photographs, not just this photograph. And I recall he was showed first a photograph.
Mr. Fowle, you can argue about these things in in your submission. We don't have to cover everything when a witness is understanding.
But, Mr. President, all I was trying to suggest is that learned counsel should be fair to the witness and not just showed him a particular piece of evidence taken in isolation from everything that he was showed. He is being trapped in order to say something that may be incorrect. He should be given the same material on the basis of which he made a particular statement, and not just things taken out of context or in isolation. He should be fair to the witness.
Mr. Stamber, proceed.
Thank you, Your Honours. Will you answer the question, sir?
Sorry, I said we go into private session.
I thought you were
I
there
noticed
already.
we've not. Thank you.
We're in open session, Mr. President.
Thank you, Madam Court Officer. I'd like to move on to the logbook that you mentioned earlier. It's at tab 8A of the Ruto Defence First Bundle, Ken D09 0038 0498. And I'd ask the Court Officer to call up page 0665.
Mr. Steinberg, could you please repeat the page you would like to be published?
0665, please.
Thank you.
The page is being shown to the witness, Mr. Steinberg.
Thank you, Madam Court Officer. Mr. Witness, I refer to the second entry dated the 9th of May 2007. I'll just read it out for the record. A visit by Honourable MP Eldoret, I believe it should be North, constituency, Honourable William Ruto, with other guests, i.e. Area Councillor Mr. Mutai and CDF Chairman Eldoret North, Mr. Mayo. I'd just like to confirm with you, is that the same Mr. Isaac Mayo you spoke of in your evidence?
Yes.
That's the same Mr. Isaac Mayo who you say...
Wait. Did he speak in private or public about the gentleman you referred to?
When I get into details of the contact with the witness, I think we would have to go into private. Perhaps it would be safer just to do it just for two questions, to go into private session, Your Honour.
Private.
We are in open session, Mr. President.
Thank you, Your Honours. Could I ask you please to call up Madam Court Officer of the same series, page 0652. 0652.
Mr. Steinberg, page 0652 is being shown to the witness.
Thank you, Madam. Mr. Witness, can you please note the date of the third entry, 1st of August 2006? You confirm that?
Yes.
And you confirm that the next entry appears to be the 5th of September 2006 and opens with the words, "The school opened with a good number of students," etc. You see that?
Yes.
The gap between the 1st of August and the 5th of September, will that correspond with the normal school holidays? Mid-year holidays?
Yes.
And would you agree then that during the holiday time there were no entries made in the logbook?
Yes.
Would you say that's normal in schools in Kenya?
Yes, it is normal.
And on that point, I don't think we need to go to each of these pages, but at page 0655, we have a last entry of the 8th of November, 2006. And on page 0656, the following entry is dated 9th of January 07, and again starts with the words, "The school opened officially with a few students reporting." That would be consistent with the Christmas break, correct?
Correct.
And at page 0673, we again see a break from the 1st of August 2007 to the 4th of September 2007. Again, the mid-year break, correct?
Correct.
And then at the end of 2007, page 0687, the last entry appears to be dated the 6th of November 2007, which describes a chemistry practical. Page 0688, there appears to be an incorrect entry dated the 6th of November 2008, which is crossed out. And on the next page, we have 2008 Term 1, page 0689. So again, no entries over the Christmas holidays. You would agree that that is normal?
Yes.
Thank you. Do you recall being shown by my learned friends a Board of Governors, the minutes of a Board of Governor meeting of the
public session?
Your Honours, I'm aware of location D. I won't mention any names.
Tab.
Your Honours, I'll just find it quickly. It's dated September 21st of September. It's at tab 16, Your Honours. Ken DO9 0038 0427. And at 0428, the minutes record the discussion of a harambe, and I'll just read it out. It says, the members suggest to go and see Mheshimiwa Ruto. Who does that refer to, Mheshimiwa Ruto, to your knowledge?
It is Honorable Ruto was the MP.
Honorable William Ruto, correct?
Yes.
And then there are three members who are named to do this task, and a fourth member was to book an appointment with the MP. Is it correct from this that we can infer that as of September 2007, the institution at location D was planning another harambe at which Mr. Ruto was going to be consulted about? I think we can put it at that level. Would you agree with that?
It is possible, yes.
Now, the date that you've given in your statement for the harambe was the 19th of November, correct?
Yes.
Would that fall during the school holidays?
It is towards the closing.
We have seen the last entry of the logbook in 2007 as being the 11th of November. I showed you that. Is that correct?
Yes, you showed me.
And the previous year, we saw that the school closed on the 8th of November. Remember that?
Yes.
So the 19th of November is well past both of those dates. Isn't that right?
It is right.
Thank you. We move on. Your Honours, I see the time. I'm afraid with the technical issues and the court's judgment, I will probably need another 15 minutes.
We'll take our morning break now and come back in 30 minutes. Court will rise.
All rise. All rise. We will Please be seated. We will swap.
Thank you very much. And witness, welcome back. Mr. Steinberg, we're in public session.
Thank you, Your Honor. We can continue so for a few minutes. Mr. Witness, welcome back. You were asked various questions by my learned friend from Mr. Ruto relating to the composition of the Board of Governors of Location D. Do you recall that?
Yes.
Can you help the court, please, Mr. Witness? Is it a legal requirement in Kenya for a school to have a Board of Governors?
Yes.
And is it correct then that at all times there should be persons available to fulfill that function?
Yes.
We've noticed from documents that were shown to you by my learned friends, and I don't think we need to call it up. I'll refer to them for the record. It's Ken D09 0038 0080, Ken D09 0038 0426, and 0038 0427, and finally 0038 0429. They're at tabs 11, 15, 16, and 17, respectively, of the Ruto Defence Second Bundle. Mr. Witness, you recall that those documents established that the Board of Governors of Location D had expired already in 2007. In fact, from the first document at tab 11, it appears it expired already in July 2007. You accept that?
Yes.
And at tab 16, we see that the board, despite the fact that their term had expired, the Board of Governors met again on the 21st of September. You recall that?
Yes.
And the last document that was shown to you is at tab 20. It's Ken D09 0038 0435, which purports to appoint a new Board of Governors, including the two persons whom you mentioned in your statement. You recall that?
Yes.
And according to this document, the term ostensibly began on the 1st of April 2008. Correct?
Correct.
So in the documentation, we have a gap between September 2007 and September 2008, where we don't know who the individuals are from the documentation who were acting as the Board of Governors. Is that correct?
It is April, not September.
That is definitely not our understanding of the record, and I do not think that my learned friend is getting things correctly. Perhaps he should put the documents to the witness, and then the witness answers the question. But certainly we don't think that is correct.
Firstly, if I can correct, when I misspoke, I meant between September 2007 and April 2008. Your Honours, the documents speak for themselves.
That's really what I was thinking. And what I said to Mr. Fowl, who wanted to object to some of your questions, also applies to you. Yes. Counsel should be discerning in knowing what is more appropriate to do in submissions at the end of the day versus keeping a witness on the stand and dragging him through every argument counsel may see fit to make in a case.
Your Honours, duly noted, the purpose of approaching this with a witness was to firstly establish that there must have been a Board of Governors, And secondly, to establish that he had no further knowledge other than what is contained in these documents. And I think we can then move on. I'd like to move then to your questions that were asked to you by my learned friend for Mr. Ruto regarding the women and youth meetings that are contained in your diary and described in your second statement of the prosecution, that is Ken OTP 0109 0071 at 0076. Your Honours, I understand this is indeed at tab 21 of the prosecution binder. Can you confirm that, please? Yes. Mr. Witness, at paragraph 30 of that statement, well, let's start with paragraph 32. You mentioned that the women's event at Mr. Ruto's house was a yearly event. Is that right?
Yes.
So it wasn't just something which happened in election years, correct?
Yes.
And what was the purpose of those annual meetings?
No, I believe it was just because of happiness. Then people meet and talk.
And did it have anything to do with the time of year at which you say this took place, on the 26th of December?
It didn't have a specific time of the year.
I see. Let me then take you to paragraph 30, and I'll read it out to you. This is to do with the youth rally. You say the rally for the youth at Ruto's home is a yearly event where Ruto gives out money for Christmas. Is that right? Is that what you told the investigators firstly?
Yes.
Is that correct? That this is a yearly event and it's to do with Christmas?
No.
What is wrong about that?
What is wrong is that the youth meetings it is not yearly. It is once in a while.
So let me understand you correctly. The women's meetings are yearly, but you say the youth meetings, I'll rephrase. In your statement, when you say the women's meeting was a yearly event, that's correct. You confirm that?
Yes, at that time, yes.
And in the same statement, when you say the youth meeting was a yearly event, that was incorrect. Is that
Yes.
what you're saying?
Yes.
You see, I put to you, Mr. Witness, that in fact, what you told the investigators was correct. These were not political events, but these were events held yearly at about Christmas time. Isn't that right?
Mr. President,
Yes.
that's argumentative, and there's no basis for that assertion to be put to the witness.
I'll leave it at that, Your Honours. Now, you have spoken a lot, we're in public session, but you've spoken a lot about the lady and her circumstances and her involvement with the prosecution. Is that right? You know who I'm talking about?
Yes.
And Your Honours, may I go into private session for a few questions on this point?
Private session.
We're in open session, Mr. President.
Mr. Witness, my learned friend showed you a schedule of payments that you received whilst you were under the care of the prosecution. You recall that?
Yes.
And it was put to you that there were no payments made to you over the period of the 6th to the 8th of July, or no payments recorded over the period 6 to 8 July 2013, when you were interviewed by the prosecution in the location you have mentioned. You remember that?
Yes.
Can I ask the court officer to call up document KenOTP 01130296. Can you call up the redacted version of that, please?
Mr. Steinberg, the redacted version of document CAN OTP 01130296 is presented to the witness.
You see, is that your signature at the bottom of that document, sir?
Yes.
Now, is it correct that you were signing for receipt?
Mr. President, we unfortunately do not have that document displayed on our screens.
I beg your pardon, perhaps can we broadcast that document? Your Honours, this is it's not in the prosecution bundle. I'll ask it to be broadcast. This is this is rebuttal evidence, Your Honours.
Mr. Steinberg, we cannot find the document under e-court. Could you please give us the ERN number of the first page?
Mr. President, may I also ask whether this material has been disclosed to the defense?
Your Honours, to answer my learned friend's question first, it was disclosed on the 13th of December last year. Madam,
the question I meant to ask is whether this material has been included in the prosecution list of materials for use in this examination with the witness.
Your Honours, I've answered that question. This is rebuttal material. It goes directly to what we submit is an inaccuracy and a misleading question put by my learned friend relating to the expenses over this period.
Mr. Steinberg, we'll leave it at that. That's the end of, let's stop the questioning now.
As the court pleases.
Yes, and that's the end of the examination. That's what I meant.
Your Honours, there is one final issue, matter of housekeeping, and that is to assign a PIS number to the prosecution PIS.
Oh, yes.
The prosecution PIS related to witness KEN OTP P0604 will bear the number KEN PIS 00010073.
Thank you.
Mr. President, we make the same request for the Ruto Defense PIS. We do not propose to ask any questions of this witness. Thank you.
Thank you, Mr. Fowl.
With your permission, Mr. President, there is a transcript of an audio that we produced yesterday. The wrong transcript was put in. With your permission, we would like to make the correction on record. We have corresponded with the court officer, and they asked that we do the correction on record. With your permission.
Please proceed.
With your permission, Your Honor, I will request my case manager to read out the correct ERN number.
Your Honours, we apologise. We omitted the wrong transcript yesterday with reference to real-time transcript 136, page 116, lines 9 to 10, and page 118, lines 19 to 20. The audio that was admitted concerning the 25th of December 2007, KEN D11 0013 0028, admitted as EVD 48 for the same defence. We admitted as EVD 49 the wrong transcript. On the record, the transcript currently admitted as EVD 49 is KEN D11 0014 0209. However, we would request that EVD 49 instead be Ken D11 0014 0568, sir.
Where is the tab again?
That will be tab 12, sir. It's the transcript for the 25th of December 2007.
Prosecution, do you have any observation on that?
Your Honours, I'm informed that what my learned friend for the case manager says is correct. We have no objection.
So the correction is affected.
The document KEN D11 00140568 will bear the number EVD T D11 00049. And I take this opportunity to inform you that the PIS of the defense for Mr. Ruto related to witness KEN OTP P 0604 will bear the number KEN PIS 0001 0078.
Thank you very much. And Mr. Kiginkatwa, Mr. Fowl had indicated he had no wish for further question for this witness. Is that the same with you?
Yes, the same with us, Your Honor.
Thank you. And to the parties, is there any reason why the witness should not be discharged from his subpoena? Prosecutor?
None that I can think of, Your Honour.
Same here, Mr. President.
No, Mr. President.
Thank you very much. Witness, thank you very much for staying part of the proceedings all these days with those questions from counsel. And we thank you very much for attending to answer the questions asked of you. We know it's a difficult sitting, or as the case may be, having everyone asking you questions, including the judges as well, from time to time. Thank you for answering them. The chamber will assess your testimony alongside the other evidence in the case when the time comes. You are discharged from the stand as a witness, and also you are discharged from your subpoena. You've done your job. Mr. Mutai, thank you, Mr. Mutai, for again, on your part, sitting patiently and assisting the witness.
Thank you, Mr. President, and thanks to the court too.
Thank you. You will now be escorted from out of the room in the video link location.
Yes, Mr. President, I will escort Mr. Mutai and the witness out, and I will confirm when they're out of the room. Mr. President, the witness and Mr. Mutai have left the video link room.
Thank you. And is it the case that the next witness is on standby?
Yes, Mr. President, the next witness is on standby.
And I understand that the next witness has counsel. Is that the case?
Yes, Mr. President.
All right. The counsel may be brought into the room.
Okay, Mr. President. For logistical matters, I would just request that we have a few minutes for the next counsel to come in.
All right.
Thank you.
Your Honours, perhaps if I can just inquire while this is being taken care of, will it be possible to start with the next witness before the luncheon adjournment? If so, we just need to do some rearranging on this side.
No, we will not be starting with the next witness. What we propose to do once the council comes in, we attend to submissions and that may be engaged in the proceedings.
Thank you, Your Honours.
Yes. Mr. Steinberg, there is a pending application, isn't there, for in-court protective measure?
Your Honours, my learned friend Mr. Garcia will speak to that.
All right.
Mr. President, the counsel of the next witness is present in the video link room.
Thank you very much. Welcome, sir. Could you please state your name for the record?
Thank you, sir. Mr. President, Your Honours, my name is James Jeroge Juguna.
Kindly spell it for the record.
James is James. Jeroge is NJOROGE. Juguna is NJUGUNA.
Thank you very much, Mr. Njuguna, and for joining us. The Chamber has been advised that you have been provisionally put on the list of counsel entitled to represent persons before the court. Is that the case?
That's the case, Mr. President.
In this matter, to represent or to appear in the interest of witness 495.
That is true, Mr. President.
We also understand that you've had an opportunity to review any statements made by witness 495.
That is also true, Mr. President.
We will note that your role in this matter is purely to represent the interest of the witness where there is the possibility of self-incrimination engaged when a question has been asked of the witness. And it is not your job to participate in the substantive testimony of the witness on the main issue. Do you understand that?
I understand that, Mr. President.
Okay. You have the right from time to time, when you feel that matters of self-incrimination have been engaged, you have the right to intervene at the appropriate juncture and inform the court of that. Do you understand?
I understand that, Mr. President.
Is it also the case that you have met with witness 495 and you've advised him of the provisions of Rule 74?
I have done so, Mr. President.
As you know, Rule 74, sub 3C, also refers to Articles 70 and 71 of the Rome Statute. Did you advise the witness of the provisions of those articles?
Yes, I've taken him through the articles, Mr. President.
Thank you. The Chamber notes that the prosecution has not originally identified any specific issues of self-incrimination likely to arise. Prosecutor, you would have the opportunity to discuss that, and it would be appropriate to do that in the presence of Mr. Njuguna, so he knows.
I can do that, Your Honours, although my learned friend Mr. Gosset will take the witness. The position is that from the information the witness has provided us, there is no reason, the prosecution has no reason to believe that any of the answers he may give will incriminate him in any of the post-election violence. However, there are certain matters...
All right, one minute. Maybe we should go into private session now.
All rise. We will lever. Please be seated.
Thank you very much. The Chamber renders its rulings first on the matter of Rule 74, assurances for witness 495, and also on the matter of restrictions on contact for the duration of the witness's testimony. The Chamber notes that an issue of self-incrimination may arise in the context of the anticipated testimony of witness 495. The Chamber has heard from the prosecutor on this matter and the prosecution's undertaking. And the Chamber now renders the ruling as follows. Where issues of self-incrimination arise, the Chamber may, having consulted in particular with the prosecution, provide an assurance pursuant to Rule 74 of the Rules of Procedure and Evidence of the Court, in order to enable the witness to testify truthfully without fear of the consequences of self-incrimination. Such an assurance would, as specified in Rule 74 sub 3c, be with regard to maintaining the confidentiality of the witness's testimony and providing an assurance that the testimony would not be used directly or indirectly against the witness in any subsequent prosecution by the ICC. It is recalled that the court cannot provide any guarantee against prosecution in the domestic jurisdictions. However, in order to give effect to the assurances that the court may give, measures can be adopted, including the hearing of the testimony in camera, the protection of the identity of the witness, and the placing of relevant transcripts under seal. It is noted that an assurance under Rule 74 will not ordinarily cover any offense indicated or provided for in Article 70. In relation to Article 70, sub 1a and b, provided the witness tells the truth before the Chamber and does not present false or forged evidence, the witness need not fear incurring liability under those provisions. Article 70 sub 1c of the statute relates to, amongst other things, corruptly influencing a witness. In this instance, the Chamber notes that the prosecution has undertaken that any evidence provided by the witness before the Chamber in this case will not be used against him for purposes of subsequent prosecution under Article 71c. Accordingly, the Chamber rules that information provided by the witness during his testimony before this Chamber may not be used in any subsequent prosecution against him pursuant to Article 70 sub 1c. In hereby granting the Rule 74 3c assurances to this witness on the understandings and with the modifications just outlined, the Chamber has been mindful of the factors specified in Rule 74 sub 5. In order to give effect to the assurance, the Chamber orders that for any part of the testimony of this witness where issues of self-incrimination arise, the following measures will apply. 1. The evidence shall be given in camera, that is, in private or closed session. 2. The identity of the witness and the content of such confidential testimony shall not be disclosed in any manner. 3. Each of the accused, counsel in the case, both prosecution and defense counsel, the parties, participants, and court staff present or otherwise with access to the evidence are hereby specifically cautioned that breach of this order may result in sanctions under Article 71 of the Rome Statute. 4. The relevant confidential transcripts of the evidence of this witness will be placed under seal. And 5. The court will apply appropriate protective measures to any subsequent decisions in order to give effect to this order. It will be primarily the responsibility of the parties to ensure that all questioning which may touch on aspects of the witness's evidence likely to give rise to issues of self-incrimination is conducted in private or closed session. The witness or counsel appearing on his behalf may, in the same manner, also request private or closed session if it is anticipated that any answer to any particular question may give rise to self-incriminatory testimony. Counsel assigned to the witness is directed to ensure that the witness is fully informed of and understands this ruling prior to the commencement of the witness's testimony, and for that purpose the testimony of the witness would only start today after the luncheon break, which is at 2:30 our time. That gives counsel ample time to meet with the witness in order to apprise the witness of the ruling of the chamber. Finally, restrictions on contacts with witnesses during their testimony would apply in respect of witness 495, in particular for the duration of his testimony. Counsel for the witness is only permitted contact with the witness on the conditions applicable to the legal representative of dual status witnesses. Accordingly, counsel should refrain from holding any substantive discussions with the witness about the topics that are to be dealt with during his evidence or the exhibits which may be produced. But counsel assigned to the witness may give him advice at any time in matters relating to Rule 74, that is, matters of self-incrimination. Moreover, the basic principles for contact with witnesses are set out in the witness preparation protocol, and they shall apply in respect of any contact, whether before or during his testimony, including any contact with counsel. These principles prohibit coaching, training, or practicing of testimony, as well as any attempt to influence a witness to testify to factual events that the witness did not observe or perceive. That concludes the ruling of the chamber on the matter of Rule 74. The next ruling concerns the in-court protective measures applied for by the prosecution. On the 28th of August 2014, the prosecution requested the usual menu of protection, that's image and voice distortion, use of pseudonyms and in-camera sessions, and redactions to public records where necessary to prevent identification. On the 5th of September 2014, the VWU provided its observations supporting the prosecution's request. As requested by the chamber, the defense for Mr. Ruto and Mr. Singh have registered their observations as well as the counsel for victims. Having considered the specific circumstances of this witness, as well as the observations provided by the VWU and the oral submissions of counsel, the Chamber considers that the requested protective measures are necessary and therefore grants them. In other words, the use of pseudonym for the duration of the trial, voice and image distortion, testimony to be given in private session for any identifying part of the witness's testimony, and should portions of the private session transcript be reclassified as public, redactions to be applied as necessary. And of course, part of the circumstances the Chamber took into account matters pertaining particularly to the Rule 74 assurances given earlier. That concludes the ruling of the Chamber on the matter of in-court protective measures. I note now that it is 10 minutes to 1. This will be an appropriate time for us to take our lunch break, and then we'll come back with the witness on the stand. Court rises.
All rise. All rise. We will lever. Please be seated. We will s'asseoir.
Thank you very much. Nairobi, you with us?
Yes, Mr. President, we're with you.
All right. Thank you. Witness 495 is on the stand. It's on the witness seat in Nairobi.
Ndio, niko Nairobi.
The witness, yes, I'm here in Nairobi.
Thank you. Can the court officer please administer the solemn declaration to the witness?
Yes, Mr. President.
Ninatamka kwa dhati ya kwamba nitasema ukweli.
The witness, I solemnly declare that I shall tell the truth, the whole truth, and nothing but the truth.
Thank you. And Mr. Ngujuna, we again recognize your presence for the record.
Thank you.
Witness, thank you very much for joining us, and welcome to the ICC and to the proceedings, even though you are joining us by video link. We still welcome you. And I say joining us in the courtroom. It's a little awkward to say joining us in the courtroom, but I must say that. Normally, other witnesses have been here with us in The Hague, and I tell them that the courtroom belongs to them as it does to each one of us in the courtroom. I do not know how much of us you do see from where you are, but take it that you are very much a part of the proceedings like anyone else participating in it. You are a member of the international community to which this court belongs, so this is your court as well. The whole idea is to encourage you to feel at home during your testimony. There is no need to feel unduly stressed by the experience of giving testimony before the chamber. The lawyers on both sides of the case will take their turns in asking you questions, beginning with the prosecution lawyers who required you to attend the court and give testimony. They will begin asking you questions in what we call examination in chief. Generally speaking, examination in chief. The defense then will take over when the prosecutors are done asking you questions. The defense lawyers will take over and ask you their own questions in cross-examination. And it is all about questions. They're asking you questions and you needing to answer those questions. I'd like you to keep in mind, please, at all times that the lawyers who are asking you these questions are simply doing their work. The questions may be difficult at times. At other times, the questions may seem to you pointless. but I will ask you still to answer them to the best of your ability, unless the chamber tells you not to answer any particular question. It's important to not get too concerned with whether or not the questions you are being asked are fair to you or not. We will worry about that. The judges in the courtroom. It is a major part of our work to ensure that witnesses are not treated unfairly because they are sitting down and made themselves available to answer questions. We do not want the lawyers to abuse that situation and ask unfair questions to witnesses. That's why I tell you, do not worry about the fairness of the question. Just concentrate on the answer you have to give to particular questions. If we tell you not to answer questions, then you will not answer those questions. And if the need arises for us to do that, you can rest assured that this is something we have no difficulty doing. We'll try to protect witnesses and make sure that they're treated in a dignified and fair manner. To assist us in doing our work, and also to make it easy for you, it is important that you listen to the question that is being asked at any particular time. Listen to the question one at a time. Make sure you understand the question that has been asked of you. Once you've understood the question, please answer it as directly as possible and to the point, and stop and let the person who asked you the question ask you another one or ask you a follow-up question. Do not try to use the one question you've been asked to tell too many stories that links into every different angle of the story. Answer one question at a time and let the lawyer who asked you the question ask you the next one. Be truthful in your answers to the question. That is very important. You've already sworn to do that or given your solemn declaration to tell the truth. That is all that we ask of you. Please tell the truth at all times. In doing that, it may be the case that you have not understood the question. Do not be shy to say that, to say you do not understand the question. In also telling us the truth, it may be the case that you may not remember the answer. You tell the questioner or the court that. It may also be simply that you do not have an answer. You do not know the answer to the question. It's all right also to say that. And we leave it to the lawyer to see whether they can try and assist you in remembering or jogging your memory or pointing to you some information that may help you answer the question better. But it is important, again, to just listen to the question, understand it, and answer it. Do not try to guess at an answer. If you must guess at an answer, it helps if you tell us that that is a guesswork, but try to avoid guesswork. Also try to avoid drawing inferences unless you must draw them. When I say inferences, means answer something that is not obvious, but you only arrive at it when you put two things or three together. You say, well, if this plus this are there, then the third thing must be right. Then you give us that third thing. try to avoid that. The example I use is mathematics. We're all taught in school that 1 + 1 = 2. So that 2 = 2 is the inference you draw. Try not to give us that. We're more interested in your 1 + 1. And then let the lawyers and the chamber work out the mathematics, whether it equals 2 or not. Now, there's one important aspect of our work, your work now, that I need to draw your attention. When I say your work, it means you've come here to tell us a story, to answer a question. If you've got the answers to the questions, it is important that whatever you tell us, it's rightly understood by everyone, and the record of it is made and kept by the court. To do that, we have a team of court staff who are helping us. They're very much part of the work. Without them, we cannot do this successfully. They are the interpreters and the court reporters. You will not see them from where you are, but they hear you only through the use of their headphones. They are connected to the audio system in the courtroom, so they need to hear you clearly and correctly. To do that, it is important that we do not have two people overlapping on the microphone. So you are talking at the same time as I'm talking, or the prosecutor is talking at the same time you are talking. We try to avoid that, and in order to help us avoid that, we've come up with what we call the 5-second rule. Because we're hearing you by video link, it is particularly important that the 5 seconds rule be observed. 5 seconds rule is counting up to 5 in your mind before you start answering a question that has been asked. So you wait until the questioner has finished asking you the question, and then you count to 5 in your mind, and then you start answering, so that while you're counting to 5, there is a pause that is created. During that pause helps to clear the microphone to ensure that two people are not talking at the same time. So when you now start answering the question, we would have heard you from the beginning of your answer to the end of it. And the person asking you the question also knows to wait for 5 seconds after you're done answering to ask you the next question, again, to avoid overlapping speakers on the microphone. Do you understand?
Nakuelewa.
The witness, yes, I understand.
It is very, very important, please, to keep this in mind. It is also important for you to speak at a moderate pace. Do not speak too fast. The reason for that is also to help the interpreters. You are speaking in Kiswahili, and what you are saying is being interpreted by an interpreter, and the court reporter would have to record all that. So if you speak too fast, the interpreter may not be able to follow you easily. So that it is for that reason that you need to speak at a moderate pace. Not too slow, but not too fast. Just pace yourself in a way that allows somebody who's interpreting you to capture what you're saying. We will try to remind you from time to time, but help us with also keeping all that in mind. Now, we understand that Mr. Sanjuguna has informed you that it is an offense that the ICC to tell a lie deliberately. when you are giving your testimony, we also understand he's told you that it is an offense at the ICC to give evidence which you know to be false or to be forged. I remind you, please, to keep all that very clearly in mind. I also need to briefly inform you that you are required to not be disruptive during your testimony and to follow the directions given to you by the chamber, because failing to do that and follow the direction of the chamber may result in certain sanctions against you, which may include even a fine. So far that has not happened with any witness who has testified, and we hope that you will not be the first. We also understand that Mr. Njuguna has advised you that you have a right to object, and he is there to help you with that, but also keep that in mind. If any question you're asked may lead to you incriminating yourself, Mr. Njuguna was specifically retained by the court to assist you with such objections. There are some measures that, when such objections are made, the chamber may still require you to answer the questions after giving certain assurances, which we've already given. Mr. Njuguna was in court when we made a ruling earlier today, granting certain assurances to you. And we've also outlined in that ruling the measures that the chamber has indicated in order to give effect to the assurances we have put in place, or we've given. So with all that in mind, the first questioner to you would be Mr. Garcia, one of the lawyers for the prosecutor. Once more, thank you for joining us, and listen carefully and answer the questions. Thank you.
Good afternoon, Your Honors. Just, if I may, before I start my questioning of the witness, one simple observation is that I've noticed that in the several interactions between the witness and the OTP, the witness has expressed himself in English during statement taking and interviews. And I know that, if my recollection is correct, for another previous witness, I understand that there is an interpreter who is present. Maybe it can be suggested to the witness whether he is able, it seems from the material that I have in front of me, that the witness is able to express himself in English, and should he encounter some difficulty along the way with anything that he wishes to express more clearly, there is an interpreter on hand, and we can resort to the interpreter. So I leave that in the court's hands, obviously.
That is indeed a good matter to raise. Witness, we note that you
understand you, says the witness.
Witness, what we note that you now so far has been speaking to us in Kiswahili, and there is interpretation going on. Of course, I understand why you want to speak in Kiswahili, if it is the case that that is the language that is more native to you, even though you can also speak English. That is, the concern is understood. People who are testifying in court want to retain control of the language they will use in communicating. That's all right. But it's often the case that witnesses are also able to speak English very proficiently. We will prefer in those circumstances that such witnesses do testify in English. The reason for that is it helps to reduce some arguments about whether the interpretation that was given of what was said was correct or not. So it is best that the witness starts in English, in this case, and if, as the testimony progressed, if there is a real need from time to time for the witness to express themselves in Kiswahili, we will accommodate that. Do you understand?
Nakuelewa, lakini naomba niendelee na Kiswahili.
Witness, yes, I can understand you very well, but I would like to request that I be allowed to testify in Kiswahili.
Mr. President, I had hoped to say something before the witness could respond, to the effect that we would, on our part as the defense, particularly Mr. Sang's defense, we would be happy that the witness tries to speak in English, and if it becomes difficult, we can refer back to Kiswahili. That's what I'd wish to say.
Let's go to private session.
We're in open session, Mr. President, and I take this opportunity to remind the prosecution to be careful with his PIS.
Thank you, Court Officer. Now, Mr. Witness, just be mindful of the fact that we are back in public session now. There's a question that remained unanswered from our private session, and the question is the following. I asked you in regards to location number 1 on page 2 of your PIS. Whether you can tell us what was the predominant ethnic group at location number 1 during the elections and post-election violence time.
Kalenjins.
Were there any other ethnic groups residing in location number 1 at that time?
Yes.
Which ones?
There were Luos, Kikuyus, Luos and Kikuyus, and even Luyas.
Now, Mr. Witness, if you're able, would you be able to tell us in terms of, roughly in terms of percentage, how many, what percentage of the population was Kikuyu at the time?
I cannot estimate.
Let me ask you this. Would you say that it was more or less than 10% of the population?